Government Business Notice Number 4, standing in the name of Mr Burgoyne to present the Petroleum, Planning and Water Legislation Amendment Bill 2025, Serial 11.
Minister.
Madam Speaker, I present a bill titled Petroleum, Planning and Water Legislation Amendment Bill 2025, Serial 11, and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, I present a bill entitled the Petroleum, Planning and Water Legislation Amendment Bill 2025. The purpose of this bill is to amend the Petroleum Act 1984, Petroleum Environment Regulations 2016, Planning Act 1999, Planning Regulations 2000 and the Water Act 1992 to remove provisions for third-party merits review of decisions. These amendments support this government's commitment to rebuilding the Northern Territory economy. They will improve certainty in decision-making for developers and proponents and improve economic outcomes for the Northern Territory. Madam Speaker, there are two forms of review that can be used to challenge government decisions. Judicial review is a common law right that considers whether a decision was lawful and if the person making the decision was authorised to do so, regardless of whether legislated or not. Judicial review is undertaken by the Northern Territory Supreme Court. Merits review is only available where legislated. A merits review considers whether a decision was correct and preferable in accordance with the law and that the decision made was the best that could have been made based on the relevant facts and available information to the decision maker. Merits reviews are conducted by the Northern Territory Civil Administrative Tribunal, otherwise known as NTCAT. This bill deals with merits review, not judicial review. It addresses who has standing to seek merits review of certain decisions under a range of Northern Territory legislation. As a general principle, standing for applicants or proponents to seek a merits review is considered important for procedural fairness on the basis that the applicant is the most directly affected by a decision. This bill does not remove standing for merits review from applicants or proponents. Madam Speaker, this government is determined to rebuild the Territory economy. To rebuild the economy, we must provide industry and businesses with regulatory processes that support certainty in development and investment. Madam Speaker, we are experiencing an increasing number of requests for merits review by third parties opposed to development. Appeals are sought strategically to delay projects and have successfully been through... I will just say that again, Madam Speaker. Appeals are sought strategically to delay projects that have successfully been through assessment, approval processes, and to influence community confidence in the regulation of development. We have seen several projects unable to commence and put on hold due to reviews brought by third parties. Right now, we have two reviews before the NTCAT, the Northern Territory Civil Administrative Tribunal, challenging the approval of environmental management plans for onshore petroleum activities. These reviews have been brought by organisations that are clearly opposed to the development of onshore petroleum industry here in the Northern Territory. These are environment management plan approval decisions that have been through rigorous assessment by the regulating agency and have been informed by public submission processes. Since 2020, there have been 18 third-party reviews pertaining to 10 decisions of the Controller of Water Resources under the Water Act 1992. This bill will reduce the current uncertainty, delays and disruption to the decision-making process and project implementation borne by regulatory agencies and project proponents. Merits reviews impose considerable costs on government and proponents in seeking legal advice, compiling document briefs and attending hearings. Removal of the merits review process for third parties will reduce costs to both the Territory and proponents. It will also reduce efforts to undermine the integrity of regulatory decision-making where environment groups and other parties use the merits review process to influence public views about the rigour and effectiveness of assessment and approval processes. Madam Speaker, it is acknowledged that the amendment bill will result in the removal of third-party merits review as proposed by recommendation 14.24 of the Scientific Inquiry into Hydraulic Fracturing in the Northern Territory. which required that prior to the granting of any further production approvals, merits review be available in relation to decisions under the Petroleum Act and Petroleum and Environmental Regulations, including but not limited to decisions made in relation to the granting of all EMPs, and that merits review be made available for third parties. However, merits reviews are not concerned with the safety of industry or environmental risk. And since these recommendations were proposed in 2018, a robust regulatory regime to manage risks of the onshore gas industry has been established since that time. Recent requests for merits review of decisions captured by Recommendation 14.24, which have been made after having undertaken a rigorous assessment by the regulator and informed by public submission processes, have been instigated to delay onshore gas development and to promote misinformation to the community about its risks. Government must be able to adapt its regimes to regulate as new technology, systems and information becomes available. It is this government's view that this is a timely to amend the requirements for third-party merits review for onshore gas to ensure that industry is provided the certainty it needs to invest in the territory. A move away from Recommendation 14.24 does not mean that this government does not support a robust, safe and well-regulated onshore gas industry. We recognise that this recommendation is not concerned with the ongoing safety to industry and is in fact damaging to the economic prospects of the NT. Madam Speaker, merits review provisions apply inconsistently across Northern Territory environment, planning and resource legislation. The Northern Territory's primary environmental legislation and Environmental Protection Act 2019 provides for the environmental impact assessment and approval of projects with the potential to have a significant impact on the environment. A ministerial decision to grant an environmental approval under this Act for a project with the highest risks to the environment is not open to merits review by third parties. Similarly, third-party merits review is not available to decisions to grant a licence to manage environmental impacts for mining activity in the Territory. By removing third-party merits review for petroleum, planning and water legislation, this amendment bill will establish greater consistency across Northern Territory legislation. There is no reason why some industries or development activities should be subject to third-party merits reviews and others not. Madam Speaker, there are a range of legislative requirements to ensure transparency and accountability in decision-making and other means for stakeholders to have their views and interests considered, irrespective of these amendments. Decision-makers are required to make their decisions public and in most cases provide a statement of reasons for their decisions. Stakeholders and interest parties may make submissions during consultation processes, with these submissions required to be considered by decision-makers. This includes consultation on onshore petroleum environment management plans, proposing drilling and hydraulic fracturing, notifications of applications for the petroleum exploration permit, and public consultation on water extraction licences and development applications. For pastoral interests, there are private legislated agreements negotiated through the land access arrangements administered by Department of Mining and Energy under the Petroleum Regulations 2020. These private agreements establish a direct relationship between pastoralists and gas companies, allowing discussions about development and compensation to flow between the parties. Existing legislation provides for a private agreement with native title holders or traditional owners to be in place for every granted petroleum exploration permit in the Territory. As with the pastoral industry, these private agreements set up a direct relationship between Aboriginal people and gas companies, ensuring that Aboriginal people have their representatives, often land councils, have a direct line of communication to the gas company. In the event onshore gas development is occurring in a way that is not agreed to by either pastoralists or Aboriginal people, these private agreements operate as a forum for these stakeholders to raise concerns with gas companies directly. Third parties also retain the common law right of judicial review in the Supreme Court. Madam Speaker, I will outline the amendments proposed in the bill in some detail. The bill amends the Petroleum Act 1984 to remove the provisions for third-party merits review of a decision of the Minister to release specified blocks for exploration. The amendment establishes an applicant for an exploration permit for a particular block as an interested person who may seek merits review of a decision of the Minister not to release the block for exploration. The bill also amends the Petroleum Act 1984 to remove the provision for third-party merits review of a decision of the Minister to grant an exploration permit. The bill amends the Petroleum Environment Regulations 2016 to remove the provisions for third-party merits review of a decision of the Minister to approve an environmental management plan or approve a revision of an environmental management plan. The bill does not remove the ability of an interest holder to seek merits review of decisions of the Minister as set out in Schedule 2 of the regulations. The bill amends the Planning Act 1999 to remove the provision for third-party merits review of a decision of the Consent Authority to consent to development proposals and concurrent applications. Complementary to these amendments, the bill amends provisions relating to notification requirements to remove redundant processes and references. The bill amends the Planning Act 1999 and Planning Regulations 2000 to remove the provisions for third-party review of a decision of the Consent Authority to take no further action in response to a complaint following completion of an investigation. The bill amends the Water Act 1992 to remove the provisions for third-party merits review of a broad range of decisions of the Minister of the Controller of Water Resources. Madam Speaker, this bill does not apply retrospectively. Any merits review afoot prior to commencement of the amendment bill will not be impacted by the amendments proposed in this bill and must run their course. The amendment bill will commence the day after the day on which the administrators assent. This amendment bill helps provide industry and the broader investment community with the certainty required to invest in the Northern Territory and help rebuild our economy. This government is committed to a robust and well-regulated gas industry. It is also committed to modernising and adapting its regulatory regime for onshore gas as the industry develops, evolves and matures, as is appropriate. I am pleased to commend this bill to honourable members and table a copy of the explanatory statement.
Madam Speaker.
Yes, Member for Guadja.
Thank you. I wish to move an amendment to the motion. Well, I'm just wanting to put the question, make sure that I get in before you put the question and gag it like you have the rest of this morning.
Can I just... It's here.
Yes.
You can do that, but we have to move that the question be read for... move that the question be read a first time.
Sure.
So take your seat and I'll let you know when it's appropriate for you to do that. So the question is that the bill be read a first time. Those of that opinion say aye. To the contrary, no. I think the ayes have Clark.
A bill for an act to amend the Petroleum Act 1984, the Planning Act 1999, the Water Act 1992, the Petroleum Environment Regulations 2016 and the Planning Regulations 2000.
Madam Speaker.
Yes, Minister.
I move that the second reading of this bill be made an order of the day for the first Assembly meeting after 28 days have elapsed.
Member for Guadja, you can speak now.
Thank you, Madam Speaker. Madam Speaker, I move the motion be amended to include the Petroleum Planning and Water Legislation Amendment Bill 2025 be referred to the Legislative Scrutiny Committee for review and community and stakeholder consultation. It's incredibly important that we're allowing our community members and our stakeholders to have input into this important piece of legislation that is being spoken about in this chamber, and to have the Minister for the Environment to come in here and not even award the opportunity for Territorians to have the mechanism to have a say on the legislation around the consequences that this legislation will deliver in our community is absolutely appalling. This comes as the Minister has spoken in here, the Environment Minister, also the Planning Minister, just spoke in his exact deliberation about the need for consultation, for community engagement, for stakeholder and industry engagement, yet was willing and is willing to forego the opportunity for the Parliamentary Legislative Scrutiny Committee to have a process to go out, to listen, to seek input and feedback from Territorians about this legislation. Shame on you, Member for the Breitling, Minister for the Environment. Not only this week have you defunded the environmental organisations who could provide, and they're laughing about it. I pick up on those interjections. They're picking up on those. But just days ago, they defund our environmental organisations who would be there to provide input on the need to protect our biodiversity, our environmental protections. The day later,
Silence,
they
please.
come in and they don't even allow Territorians the opportunity to have a very, very important say, Madam Speaker. It is appalling that this is the position that we're going in. The Minister, Minister Burgoyne, comes in and talks about allowing everyone to have their say. But he's not allowing everyone to have their say, Madam Speaker, because he's refusing to send this to the Legislative Scrutiny Committee. We've got a government who brought in a lobby register only days ago to talk about the importance of industry lobby groups and being open and transparent as a government, but they're not being open and transparent as a government. They're not having an open and transparent process around this piece of legislation, around the merits review. They're willing to just overlook that, steamroll ahead, and not include people in the process. They are the very people who are eroding their own democratic principles and policies that they came to the election on. Only few sittings ago, the Chief Minister came in here and spoke about the importance of having a Legislative Scrutiny Committee, but is now picking and choosing what the government sends to it. This morning, we have seen that when it gets hard and the member for Breitling, the Environment Minister, the Minister who just cut funding to the Territory's environmental groups, the Minister who spoke about robust discussions, just showed how scared the CLP are about having those robust discussions, because they're not willing to have the robust discussions. They're not willing to hear from Territorians about those robust topics, whether it is the environment, or we've seen the coward-like nature of the Corrections Minister shutting down that debate this morning because he doesn't want to talk about it. These are important. These are absolutely important discussions for the Legislative Assembly to talk about, and we absolutely urge the country Liberal government to refer this to the Legislative Scrutiny Committee. What are you afraid of? You, the government, you control the members of that. Don't you trust your own members of the Legislative Scrutiny Committee? Don't you trust that you have the numbers on that committee, but you can allow Territorians to have a say, and you're not willing to do that? That is terrible for the democratic processes. Minister for the Environment and Minister for Planning, you have an opportunity here to right the wrongs that you have delivered already in cutting environment funding, in being unwilling to listen to people who care about the environment. Send this to a Legislative Scrutiny Committee. Allow Territorians, stakeholders and industry groups to have a say. That's the least you can do as an elected member, is listen to your own constituency.
Are there any other speakers on this amendment? Member for Nightcliff.
Thank you, Madam Speaker. I would also like to see this go to a scrutiny committee. Madam Speaker, I don't mind if someone has a good idea. I don't mind who's saying it. If I genuinely think it's evidence-based or listening to the community, I'm happy to go ahead with it. So I was genuinely happy to see scrutiny committees come back. Genuinely happy to hear that they were open and looking at a lobbyist register. The scrutiny committees exist for a reason. Despite the fact this side have stacked them with the majority of their members, they still exist, and I don't understand why they are going to pick and choose what goes before scrutiny committees. No one in this chamber can talk about transparency genuinely unless we're actually providing transparency. What we saw yesterday with the proposal for the lobbyist register has filled me with despair, because it is toothless and gutless, and is demonstrating to me that there is actually no genuine desire from this side of the chamber to actually be transparent. Let's not make this political. These committees exist for a reason. Use them and stand by your word and actually provide the public with some transparency.
Member for Braitling.
Thank you, Madam Speaker.
Are you speaking on the amendment?
Correct.
Yes.
This legislation, Madam Speaker, is a repeal of legislation. Let me be very clear, not new legislation. For years, Madam Speaker, we have heard from the previous Labor government of the strong, robust processes that they have put in place. This as it relates to environmental protection right across the Northern Territory. To send this to Scrutiny Committee would essentially be debating the merits of removing merits review. Let's be very clear about what we are actually debating today. Labor for years, Madam Speaker, Labor for years ignored calls for a Scrutiny Committee. You didn't want it for any legislation.
Silence, please. Come on. Silence, please.
As this is a repeal of legislation, Madam Speaker, not new legislation, as this is the case, we will not be supporting the amended motion. Thank you, Madam Speaker.
Opposition Leader.
Thank you, Madam Speaker. And it's actually quite ridiculous listening to the member for Braitling, who is saying we're now picking and choosing what scrutiny that we want as a government. Like, that does not make sense, Madam Speaker, to any Territorian who knows the way that Parliament works. We want to see good governance in the Northern Territory. We want to see accountable government. We want to see a transparent government. Doesn't matter who's in government, Madam Speaker, to Territorians. They want to see good government. They do not want to see a bad government. Has anyone in this chamber ever walked around the Northern Territory and said, hey, do you support a bad government in the Northern Territory? Yep. Yeah, so exactly. We want to see good government. Territorians want to see good government. The whole point. And now it's sounding more and more, Madam Speaker, which is the huge concern for our Labor opposition, that it sounds like the CLP government has brought forward the motion of having Scrutiny Committee back for legislation without ever having the intention to send legislation to the Scrutiny Committee. So it is tokenistic, it is disingenuous, and it is an absolute schmozzle for the CLP government to say, we're bringing back transparency, we're bringing back accountability, we want to be a good government, but have completely removed any pathway, process or procedure to allow for the processes of Parliament to scrutinise, regardless if you're a CLP committee member, regardless if you're a Labor committee member, regardless if you're part of the crossbench and you're a committee member. You are removing the very process that for 4 years the CLP opposition talked about bringing back the Scrutiny Committee. And now the CLP government, Madam Speaker, the true turnaround, the 180-degree turnaround, is that they do not want to send a single piece of their legislation to the Scrutiny Committee that they called on and made a big song and dance for bringing back to the parliamentary process. And I really hope, Madam Speaker, that the elected members of the CLP government go back to their electorates after the Parliament sitting weeks. We know it's always a big week for everybody. They go back and they look their constituents in the eye and they say, we actually didn't have any intention of scrutinising ourselves because we're just going to do what we want. We don't actually care now what Territorians want us to do as government. We're going to forge away, we're going to make decisions, and we're not going to listen to the people that voted us in. And that's the biggest slight on democracy, Madam Speaker, to see the member for Braitling as the Environment Minister, as the Planning Minister, then say, we actually don't care about scrutiny. Oh, we're repealing this piece of legislation. Yes, member for Braitling, we understand what repealing legislation is on this side of the House. We want to know what Territorians think about your decision, because who have you talked to? No, apparently you don't even believe in consultation.
Okay, less
apparently
interaction.
Consultation is not in the vocabulary. Madam Speaker, apparently consultation is not in the vocabulary or the thinking even, or the actions of the CLP government. It is not a part of their toolkit, Madam Speaker. They do not respect the process of consultation and engagement. They think hearing one story means that it's everything. They don't go and do their homework. They're still acting like they're in opposition. They can say anything they want and it's not going to matter for Territorians. It absolutely does. When you're in government, Madam Speaker, it absolutely does matter to Territorians. It matters to the organisations, the businesses, the industry, the everyday Territorian. It matters to them. This impacts them, and we've seen already today what the government is intending. We know firsthand, Madam Speaker, that they're not even responsible enough or brave enough to meet with the people that the decisions they are making now or proposing to make will affect and impact drastically on. And we've talked already, the member for Gorge has already talked, Madam Speaker, about that with the Corrections Minister being too chicken to even talk to the corrections officers. The legislation that he's bringing forward, we just got a briefing invite with less than 2 hours' notice. Oh yeah, by the way, here's the briefing, be here or that's it, you miss out. How ridiculous. 2 members of Parliament weren't even included in that. So where's the democratic process in that, Madam Speaker? So I really hope that the member for Breitling is not going to be arrogant and continue on the line that his team is doing around not caring about what Territorians think, say and want to see in legislation, whether it's new legislation or repealing legislation, member for Breitling. Madam Speaker, I sincerely hope the government looks themselves in the mirror and realises they're letting Territorians down.
Are there member for Berkeley?
Oh, thank you, Madam Speaker, and it is a bit rich, the opposition coming in here and talking about scrutiny, because under 8 years of Labor there was no scrutiny whatsoever. Now, this motion, Madam Speaker, is...
calm down.
Madam Speaker, the motion put forward by the member for Breitling is for this legislation to be an order of the day at the next Assembly meeting after 28 days. Now, this...
Please take your seat, member for Berkeley. What's your point of order?
Standing Order 1, I ask for your determination. The Minister for Housing, the member for Berkeley, is talking about the amendment. We're actually talking about the motion as amended.
Please continue, member for Berkeley.
Thank you.
Thank you for bringing that to our attention.
So the motion put forward by the member for Breitling is for the legislation to sit for 28 days. The motion to amend that particular motion is just playing politics, Madam Speaker. It's nothing more, it's nothing less than just playing politics. It's coming from the side over there with no credibility whatsoever in regard to scrutiny. In fact, what we've heard is that criticising, talking about consultation engagement, and as we know under the Labor government, Madam Speaker, and I've spoken about this in the House before, the only time that I've ever seen the member for Guadra and the member for Arnhem talk about consultation engagement was standing in front of a camera at Battery Hill holding the community engagement strategy. That's it. That's the only time they ever spoke about consultation and engagement. Now, Madam Speaker, the issue here is that, yes, there's plenty of time for scrutiny. There's 28 days while the legislation sits there. Now, every member on that side, just like every member on this side, 25 members in the chamber, Madam Speaker, anyone that wants to talk to a local member about this legislation has 28 days to do so. This is the role of every local member, Madam Speaker, is to get out there, talk to people in their electorate about legislation before this House. It's the role of every member in the House to do their job. I'll remind you once more, Opposition Leader, look, listen and learn. Get out there and talk to your constituents about what's going on in your, not only about your electorate, but get out there and talk about what's happening in the House, Leader of the Opposition, because this legislation will sit for 28 days, and I encourage every member on that side to do what we're going to be doing, and that's out listening to every constituent that we represent. That's what we do. That's how we do our business. We engage, we consult with every person that we represent. I encourage you to do so yourselves rather than coming in here and playing politics. Madam Speaker, I move that the question be put.
The question is that the amendment be agreed to. Those of that opinion say aye. To the contrary, no. I think the ayes have it. Do you want a division? Okay. Division. Thank you. The result of the division is 17 noes and 6 ayes. The noes have it. That's right. Okay. The question is that the motion be agreed to. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it.